Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists, and as uncertified podcast hosts, we try to bring our audience of trial and appellate attorneys some legal news and perspectives they can use in their practice. If you find this podcast helpful, please recommend it to a colleague.
Yeah, and if you don't like it, send it to your opposing counsel.
All right, Jeff. Today we wanted to talk about the John Eastman opinion from the State Bar Court of California. This is a decision reviewing the trial judge decision recommending disbarment of John Eastman for his participation in the events that unfolded or that came to a head on January 6, 2021. The opinion issued by the State Bar Court of California Review Department is issued June 13, 2025. We'll give a little bit of a procedural history here first, but first I wanted to tell you, Jeff, and our audience, I'm a little nervous about this conversation, and I have some biases to disclose. Maybe we'll get to that right after we cover the procedural history. But this is a hot button issue. I know Chapman University School of Law, where John Eastman was a professor and later a dean, before he left after these events unfolded. You know, that was my alma mater. I was a student under John Eastman in his con law class. I guess I am getting right into my bias disclosure, Jeff. John Eastman was a mentor of mine. I was the academic fellow for his constitutional law course. I worked with him in his constitutional law clinic on some eminent domain cases back in the time when I was in law school, 2004 to 2007. That's when the Kelo versus City of New London case came down from the U.S. Supreme Court. That was all the rage those days. I was very interested in eminent domain cases, and I worked with John Eastman on a few eminent domain cases defending churches from some of the excesses we believed of eminent domain policy. And then I also, John Eastman was also my mentor when I was on law review. I mentored my law review article also concerning eminent domain, which happened to win first prize in a legal judicial awareness legal writing law review competition in 2006, I believe. And I have supported his legal campaign in his defense from the state bar action. So those are my biases here. Let me just give an overview of where we are in the procedural history of this case. And this comes by way of Horvitz and Levy attorney and CALP alum David Ettinger at the lectern, where he gives us a very helpful summary of where we are in the procedural posture of this case. So in June 2025, it was June 13th to be precise, the California State Bar Court's three-judge review department came to the same conclusion as the hearing judge over a year ago and recommended the disbarment of President Trump's former lawyer, John Eastman. This was a 98-page decision. There's also a 5-page concurrence. We can link that in the show notes. The court said that, quote, in a democracy, nothing can be more fundamental than the orderly transfer of power that occurs after a fair and unimpeded electoral process as established by law. And the review department concluded that disbarment is, quote, the appropriate discipline when an attorney who has sworn to uphold the laws and Constitution of the state of California and the United States attempts to actively undermine the results of an election to the most powerful office in the United States with the goal of delaying or invalidating the lawful installation of his client's electoral opponent and thereby keep his client in office, end quote. And where we are just in terms of what Eastman can still do in the process, Eastman can ask the review department for reconsideration. He has 15 days to do that. I actually don't know if he's asked for reconsideration. But if, as is likely, the department's opinion is not reconsidered, Eastman can still seek California Supreme Court review of the disbarment recommendation. That's under Rules of Court Rule 9.13a. His petition for review is due 60 days after the recommendation is filed with the court. So I think that puts that at about August 12th, 2025. And as David Ettinger goes on, in the unlikely event Eastman himself doesn't ask for further review, the matter would end up in the Supreme Court anyway, because all recommendations for disbarment automatically go to the court, which can choose what to do regardless of what Eastman does. And with any case other than a death penalty appeal, the Supreme Court can deny review. Unlike other cases, however, a denial, quote, is a final judicial determination on the merits and is followed by the filing of the State Bar Court's recommendation as an order of the Supreme Court. And of course, Eastman, after that, could seek U.S. Supreme Court review. Currently, Eastman is not eligible to practice law in California. His status, that's been his status since March of last year. But I have learned the U.S. Supreme Court has said that until Eastman is actually formally and officially disbarred, he remains eligible to practice in the U.S. Supreme Court. So that's an irony that Eastman can practice in the U.S. Supreme Court, but not in the L.A. Superior Court or any other Superior Court of California. Okay, so that's where we are. And Jeff, do you have anything before we jump right into my overview of the state bar opinion?
Oh, I have biases. I think Trump and Eastman and Giuliani did more to harm our form of government than any group of individuals in a long, long time. Boy, January 6th, I sat home, watched it live. I watched Giuliani and Eastman live, giving their speech at the Oval. Yeah. I have biases. I come into this conversation biased against John Eastman.
Okay. Okay, well, let me give the overview of the state bar case. There were basically three parts to it. There was an issue over the elector memos that John Eastman wrote. He wrote 2 memos. The recipients or the target audience of the memos are in a little bit of doubt. It's also something that I'll point out, that even though Eastman was Trump's attorney, it was not clear whether Trump himself ever actually received or read the memos, and it's not clear that anyone ever took Eastman's advice as president of the United States. The memos were directed at what the vice president may or might be able to do, not anything that the POTUS might be able to do. So in that sense, I was always a little bit confused about the capacity in which Eastman was serving. Even though technically he was counsel to Trump, the advice that he was giving would have been directed to the vice president, who was not Eastman's client. But at any rate, Eastman had pointed to a potential ambiguity in the 12th Amendment, with the upshot being, does the vice president open the electors, the envelopes with the electors, and count the electoral votes, or does he just open with the person responsible or the body responsible for opening left ambiguous, probably to the Congress or to the Senate? But the 12th Amendment is ambiguous on that. It has the active voice for the president, or the vice president shall open the votes, but then it just uses the passive voice, shall be counted. So most scholars take the latter view, that the Congress is meant to count the votes and not the vice president. But Eastman pointed to the fact that just on the text, it's ambiguous and it's never been directly decided. So he took the view that the vice president gets to count and the Congress just watches. And if the vice president gets to count under that theory, and if there are alternate slates of electors, then Eastman concluded the vice president could recess the Congress for more time for states to investigate the alternate slates of electors and decide which slate is the authorized slate of electors. Now, there are problems with that theory in the sense that there were no state-approved alternate slates of electors. There were just other electors. I guess they were potential electors, that if their candidate had won in the state, they would have been the electors, and so they self-determined that there was fraud in their state's elections, and so they said, well, I'm the elector, and the state has not said so, but I say so. This obviously raises the conclusion, the official conclusion on that. I shouldn't say the official, because I think there still has not been an actual conclusive judicial finding on whether Eastman's theory is right or not. It's just it is in the vast minority or it's in a slim minority of scholarly opinion, but is it actually judicially precluded? And it sounds like to me, after reading the opinion and trying to study up in the issue in my free time, including reading Larry Lessig's book, co-authored with Matt Seligman, who happened to be the state bar's expert opinion, constitutional scholar expert in the state bar's prosecution against John Eastman. I don't think it has been officially decided whether it is actually a precluded decision. It might be not the right theory. I tend to agree that it's not the right theory, but is it a crazy theory? And I wanted to share one thing that Larry Lessig had related. He related that he recalls during the Bush versus Gore controversy in 2000 and 2001 about the Bush team's theory that the Equal Protection Clause raised a potential violation due to inconsistent recount processes in the state of Florida. And Lessig recalls talking with several of his colleagues at the time at Stanford that theory just seemed bonkers. It just seemed crazy. But he still pulled back and said, I don't know, it seems crazy to me, but should Ted Olson and the other members of the Bush team be disbarred for bringing that theory? Even if I think it's crazy? Well, I mean, no court has said that it's judicially precluded. And look, it turned out that the Supreme Court agreed with it. So even crazy theories, might wind up proving true.
Look, I don't think anybody was saying that Professor Eastman should be disbarred because in a quiet room he wrote either a 2-page or a 6-page memo describing how to thwart the election and skip counting the validly elected electors. I think just drafting a memo and having a thought experiment, or I think he called it a war game, I think that's peachy keen. He can write all that stuff all he wants. I think what distinguishes this case from Bush v. Gore was, and I'm relying on, it's been a while, but Judge Carter's ruling in the case involving the subpoena by the Select Committee of emails of John Eastman. And Judge Carter ultimately found that the attorney-client privilege, if there was one between Trump and Eastman, was waived or didn't exist because of the crime fraud exception. The key facts for me aren't that he sat and drafted this opinion or even that he shared it with President Trump. I don't think anybody should be disbarred for writing a legal memo or for sharing it with your client, Donald Trump. We don't know if he did, but if that's all he did, Professor Eastman should still be practicing law. What bothers me and what bothers other people was, I think 2 days before January 6th, Trump summoned Eastman and Pence to the Oval Office and advocated for this plan. Professor Eastman was advocating that Pence follow this plan. And again, on the 6th or the 5th, there was a private meeting between Eastman and Pence. I think maybe Pence's chief of staff advocating this plan, not just saying, well, you've got option 1 or option 2, or you could do this, you could do that. It was Eastman was advocating for his client, President Trump, that Pence do bad things. And then to follow that up on that speech with Giuliani on the day of January 6th, frothing the crowd up, saying, I saw fraud in this election last night. I think that related to the Georgia Senate race. I saw fraud. We've caught them. The ballot computers were mistabulating things. And all we need to do is have Pence send it back to the states. That's all we're asking of Pence to do. And he fired the crowd up. And then I think even after the attacks were happening, or the tourism, depending on who you're talking about, but after people were entering the Capitol, there were emails sent by Eastman, Professor Eastman, to Pence or Trump or somebody saying, yeah, it's still not too late. You could still send it back to the electors or send it back to the states, and we can uncover this fraud. I think it's more than just memo authoring and thought experiments here. It was Eastman acting as an advocate for President Trump, advocating these theories that I still find troubling today. That's where Jeff Lewis comes down on the Eastman issue.
Well, I want to take a step back, but just just to respond to a couple of the word choice that you used, that Eastman was advocating that Pence do a bad thing. Well, first of all, advocating, I'm not sure when that became a dirty word. And to do a bad thing, that's what I set up earlier. There's been no adjudication that what Eastman was advocating was just any worse than a minority view. Maybe the wrong view, maybe the view that would not be upheld in if it went before a court, but probably no crazier than the equal protection theory in Bush versus Gore, which did carry the day in the U.S. Supreme Court. My point being, you can't call a legal theory bad or disbarable when it hasn't seen the light of day, even if it doesn't command a majority of scholars. as long as it's not expressly foreclosed by, the text of the Constitution, and it's not. There was a textual ambiguity in the Constitution. This has never been decided. As Alan Dershowitz says, there is no manual that you go to when you think that there's something wrong that's happened in an election. You just follow these easy steps to challenge the election. It is a complete morass. It's completely opaque about how you go about challenging an election. And also, you only have a matter of days or weeks in which to bring this challenge.
Yeah, but let me say, it sounds like what you're saying is, look, he acted in good faith for a good faith advocacy of a minority view. I'm going to push back on that and say, I can't remember if it was an email or a deposition transcript or something from the January 6th committee where he said, maybe it was an email. Eastman said, yeah, we probably couldn't even get a single, or maybe we might get one vote on the U.S. Supreme Court who would back this theory. When you are put to pen to paper and say that the Supreme Court, a conservative court, won't agree with your plan, that's a concession that maybe you're not acting in good faith, in my judgment.
I can understand that. I don't agree with it, because I don't think that, I mean, if you were a fly on the wall in 2001 during the Bush versus Gore wargaming about the Equal Protection Challenge, maybe they would have said the same thing. Like, is this going to work? Equal protection on a voting case? No, this is crazy. But we gotta do something. We gotta buy some time. We gotta keep the pressure on. Maybe it was also bad faith that wound up and they pulled a rabbit out of a hat. We don't know.
I voted for Bush, by the way. I think he should have. I'm pleased he was appointed, or that he won that election contest. I did not vote for Gore.
Well, let's get to some of the election fraud related court filings or allegations that were at issue in the State Bar review opinion. There were a number of challenges that Eastman had alleged, and the State Bar opinion rejected them all as being not made in good faith. So the court agrees with you, Jeff. In Arizona, Eastman had alleged that 35,000 ballots lacked a chain of custody, where the margin was only 10,000 votes. I didn't see a direct response to this in the State Bar court. In Georgia, Eastman alleged that there was underage registered voters, and that the Secretary of State continues to deny this. He alleged that there was weakened signature verification process, and there was what he called porta potty precincts that lacked necessary observation. There was improper use of ballot harvesting, which at least at that point was still under investigation. The Bar Court rejected those challenges. It pointed to Eastman's allegation of dead voter, of some 66,000 dead voters who had voted, and that only 4 dead voters had been confirmed. So it was just woefully short of what Eastman had alleged. The court also rejected the allegation that that more than 10,000 votes in Georgia were cast by people who had moved out of state, because it relied on a flawed national change of address analysis, and there was a lack of evidence of widespread fraud, and the data was unverified. In Wisconsin, there was supposedly a 20,000 vote margin. The investigation claimed that 200,000 ballots were potentially illegal, and there were issues with nursing home violations, fraudulent ballots there. The State Bar Court concluded that Eastman had relied on sources that were just unreliable, and his reliance on them was unreasonable, that the nursing home claims were found to be based on speculation and not substantiated by state investigations. And the court emphasized that Eastman continued pressing these claims after courts had rejected them, and the court concluded that this amounted to recklessness or intentional misleading. And the last 2 states where there are major allegations in Pennsylvania and Michigan. Pennsylvania involved an 80,000 vote margin and 100,000 discrepancy in voter records. There were issues Eastman alleged concerning disqualified ballots and signature verification issues, where the outer envelope requirements had been struck as void for vagueness, and Eastman wanted to bring that challenge up to the U.S. Supreme Court. The State Bar opinion concluded that the Eastman's allegation involved outdated or unofficial data, particularly for the 200,000 overcount claim. And this issue had already been corrected by the Pennsylvania Department of State. And Eastman should have known that court rulings, such as on the signature verification statutes, were binding, and yet he continued to argue as though they had not occurred. What happened is that there had been a lawsuit brought against I believe the Pennsylvania Secretary of State. I think it was the League of Women Voters against the Secretary of State, and that had resulted in a settlement saying that the signature verification issues were A-OK. Eastman said, that's just one of those sweetheart settlements. We can't rely on that, but the State Bar Court faulted Eastman for not even mentioning in his briefing to the U.S. Supreme Court that the case had been dismissed based on a settlement. And then finally in Michigan, there was a 150,000 vote margin at the TCF Center. Eastman alleged misconduct in the vote counting, that this was supported by witnesses, and that there was testimony that was dismissed based on government officials' accounts. He alleged that there was some 135,000 ballots that were brought via a Chicago warehouse that appeared overnight, and that there were observer restrictions in the Philadelphia Convention Center. That was one of my favorite challenges, Jeff. The allegation that even though Michigan had a rule that said that you had to allow observers, vote counter observers, into the room, and the court said, well, they were allowed in the very first 3 feet of the Philadelphia Convention Center, and that was enough to be in the room. I might have the states wrong here, but maybe that was Pennsylvania if it was the Philadelphia Convention Center. So that challenge was rejected, as was the ballot dump theory was rejected as speculative and unsupported, and yet the court faulted Eastman for continuing to cite it as evidence of fraud, even after it had been undermined. And the observer access issue had been mentioned in litigation, but it was not upheld by the courts, and the court faulted Eastman for omitting that these suits had failed. Jeff, my main takeaway from this analysis is twofold. One, concerning the fact that many of the challenges had been raised in prior lawsuits and had not succeeded, I found unsatisfying the fact that most, if not all, of those prior lawsuits had failed because of procedural issues like standing or mootness, or it was dismissed on the basis of a settlement. I thought these are not adjudications on the facts or the merits of the election fraud challenges. Now, whatever you think about the election fraud challenges, maybe they would have failed anyway, but to fault Eastman for continuing to bring those challenges after they had been dismissed procedurally in the past, I thought rang a little hollow. That maybe, I think in the types of cases we normally talk about, if an attorney failed to mention some procedural history that was relevant to the case, that may warrant an admonition or maybe even a sanction, but they probably wouldn't have, in these cases, they would not have led to a different conclusion, I don't think, because again, the merits had not been adjudicated. It had only been decided on procedural issues. So I just thought it rang a little hollow that this would amount to disbarment for failing to note that some of these past challenges had failed on procedural grounds.
I tend to agree with you, Tim. I think some of the statements Eastman made about the results of these cases, if there were misstatements, violations of duty of candor to other courts, doesn't rise to the level of being disbarred. On a case-by-case basis, if a court or a party wanted to seek sanctions, something short of disbarment, go for it. But I tend to agree with you. It's the other conduct by Eastman that I think warrants stripping him of his bar card.
Yeah, so we're talking about, so far we've talked about the fact that Eastman has raised a novel legal issue that maybe is disfavored and not supported by scholars, but it has not been absolutely foreclosed as a matter by the Supreme Court or indeed by any court. And should that be grounds for disbarment? And then we got these factual challenges that have been raised in previous lawsuits, and they have been dismissed on procedural grounds, but should that be a basis for faulting Eastman and maybe an admonition? But so far, let me take an aside here, Jeff, and I recognize that there were a lot of crazy theories for the 2020 election. There were a ton of challenges. And of course, everyone will remember Sidney Powell's Kraken theory. And I actually had respected Sidney Powell. I had, a few years prior read her book about her time in the trenches as a defense attorney going up against the DOJ and pointing out some of the excesses in prosecutorial conduct. So I had a lot of respect for her independence at that time. And so when she got into the fray, I took notice, and then all those theories seemed pretty wild, and then they came to nothing. And I'm still taken aback by that. But here's my 30,000-foot view about why the 2020 election got so bonkers. Okay, so here it is. I want to see what your reaction is. So in 2020, of course, it's memorable not just for the election, but for COVID. And in reaction to COVID, we had a lot of different election, I call them innovations, with mail-in voting all of a sudden, signature verification requirements being changed. We had the use of unmonitored drop boxes. There was that private election funding, remember Zuckerbucks, and then curtailed election observation. That was a lot of innovations to our election season and election rules.
And let me add to the top, a presidential candidate who may have been unable to accept a loss and would employ lawyers aggressively.
Sure. No, I'll give you that. But I'm talking about just going into the election, even before any of that happened. We have, just setting the stage for how the rules were changed ahead of time. And I'm accepting that the rules were changed, and they were changed validly. That's why I'm not calling them procedural, like irregularities or violations or illegalities. I'm calling them innovations. They're new things. They may be lawful things, but they're new things, and a lot of new things all of a sudden.
Yeah, Professor Eastman, if he were on the Zoom, he would say those new things, they cheated. The Democrats cheated. And so what I'm advocating that you, Vice President Pence, do is no more than what the Democrats do, and that's cheat also and violate the rules. That's what Eastman as much as said about his justification pressing his theories that were in his two memos.
Okay, but you're jumping ahead. Okay, so I'm starting with, so in 2020, take election.
Eastman would say that just the innovations themselves are cheats. He would say that going into the election, before any votes were counted, before any votes were cast, that these innovations, mail-in ballots, unmonitored drop boxes, etc., those were cheats. The Democrats cheated.
He did challenge some of them as illegal, as inconsistent. There may be to the effect, for example, that maybe the Secretary of State changed some of the rules rather than via statute, that may be illegal. But I don't know enough about those challenges to say yay or nay. Right now, I'm just assuming that they're lawful, but they are innovations. I'm just talking about what could possibly explain why we had such a surge of zany election challenges at the end of 2020. And I'm starting with, okay, we have a lot of election law innovations in 2020 because of COVID. And then we already had a long-standing suspicion of electronic voting. Okay, I don't know if you remember, but I had read years ago CNN articles, New York Times articles, all talking about, remember 2016, it was alleged that the Russians had digitally interfered in our election. So there's always been, ever since we started having electronic voting, there's been a long-standing criticism and suspicion of electronic voting and how it might be hacked or manipulated somehow. So add that into the atmosphere, and then add in the resulting flood of election challenges. And some may be colorable and par for the course, and others were definitely far-fetched. I'm thinking of the Kraken theory, which I still don't even understand what it was supposed to be. And then you have the overall opacity of the U.S. election law and electoral system. And I go back to Alan Dershowitz's comment that there is no, slim volume you can pick up how to challenge an election. It is an open field and an endless number of ways of going about challenging things. And there have been a number of open questions on the books for decades. And then at the end of all of this, the election happens in November. You have a matter of a few weeks to come up with a factual and legal theory, not only to file it, but to have it decided in time for it to matter. And you take all that, add it together, and that equals the Eastman dilemma. That's how you get the Eastman problem. You get all of the normal difficulties of bringing a challenge to an election. You add in all of the new 2020 election innovations, the additional distrust, and then whatever other distrust that may just come by way of maybe what some people call Oval Office-itis, that you get into the Oval Office and all of a sudden the creative juices start to really flow. And then you get to this problem where you come up with a legal theory that hasn't been foreclosed anywhere, but it's probably no crazier than the Bush v. Gore equal protection vote counting theory. And then you have to come up with, okay, we have already some electors who are saying that I want to cast my vote for Trump. I think there was fraud in my state. By the way, Larry Lessig also has promoted the theory that state laws criminalizing faithless electors are unconstitutional. Remember in 2016, there was a case, Chiafalo, that where Larry Lessig was the attorney for the alleged faithless electors, Chiafalo versus Washington, I believe that case was. And he argued that under our original understanding of the Electoral College, the electors don't discharge mere ministerial functions in just doing what the state legislature tells them to do. They are sent to Washington to vote their conscience. Now, normally that means voting who they're expected to vote for, but not always. And that's why we have an electoral college and rather than a direct democracy. And so there's at least Larry Lessig's view on that is, obviously doesn't command a majority. It's been disagreed with by the Supreme Court, but I will defend Larry Lessig. I don't know. Will you, Jeff?
No.
But that's just another exhibit in favor of the argument that our electoral legal system is very complicated. There are a lot of room for creative arguments, and a lot of takes on even the fundamentals of how it works. Do we elect our presidents directly? Are the electors meant to just discharge a ministerial act or to exercise discretion? So there's not even unanimity on that point among reputable scholars.
Let me gently push back and say it is insane to suggest that a vice president could simply pick the American president. Okay? It's insane. And to say, well, it hadn't ever been rejected by a court. John Eastman's own writings suggest that he didn't really believe what he was doing had merit. What he was saying was he's violating the law, but because the Democrats cheated, they were entitled to cheat too. And let me further say, well, yeah, I'm just going to gently push back on. There are some ideas that are so crazy, so insane, they shouldn't even be given voice in the environment of this powder keg that was January 6th with the crowds and the speeches and everything else. That's my view. Off my soapbox. Back to you, Tim.
Well, on that theory, I think John Eastman's response is that he didn't advocate that Vice President Pence should pick the electors. He called that the weaker view. He did offer that as a possible view that could be supported because of the ambiguities in the 12th Amendment. But he called that the weaker view, and he thought, I can't remember, I think his word would be foolish to go that way. His argument was that we should wait, that Vice President Pence should find that there are alternate electors and credible allegations of fraud, and therefore the Senate should recess before counting those disputed slates of electors and send it back to the states to do what they will with the investigations.
On January 5th, Eastman walked into Pence's office and said, "Mr. Vice President, I'm here asking you to reject the electors." That is a direct quote that I believe either Mr. Short or Pence's lawyer gave to the January 6th committee. Now, I'm sure Professor Eastman, if he were on the Zoom, would dispute he said that. But there is evidence that Eastman advocated not just for a delay of proceedings, that he simply reject the legitimately appointed electors from the disputed states and appoint the president. He did it. He did it. That's crazy. I mean, it's crazy. Yeah, sorry. Off my soapbox.
Okay.
Back to you.
You may be right. I can't remember the specifics, but he did. I know they did offer that as a potential. I don't remember if he specifically, what he advocated. And again, go back to my point about what he advocated. He wasn't Vice President Pence's attorney. And so in that sense, I know Eastman did make the argument that, look, I wasn't anyone's attorney there. And I wasn't the attorney for anyone who mattered in this theory that I was proposing. So in that sense, I was just a private actor exercising my right of petition. I should be protected by the First Amendment right of petition.
That's bonkers.
Why is that part bonkers? I thought that's arguable. I mean, if there is a point that I understand that our state bars want to regulate the conduct of attorneys and whatever they do. So even to the extent they're just blogging in their own personal blog, I guess they could be found guilty of acts of moral turpitude for spreading false information, even when they're not representing anyone.
I'm with you. If Eastman sat in a basement, wrote the memo, or put it out on a blog, and he's not representing anybody, that's fine. And I'll go a step further. If Eastman represented Pence, and Pence said, "Hey, is there a way for me to throw the election?" and Eastman gave him these options, I don't think there's anything wrong with that. What I find reprehensible and criminal and disbarable is Eastman was Trump's lawyer and was acting as Trump's advocate inside Pence's office on the 4th and on the 5th and saying, "Throw this election." That's the part that gets me. He was unquestionably acting as Trump's lawyer. Look, why was he fighting? Why was Professor Eastman fighting like hell to prevent Judge Carter from disclosing all these emails to the select committee? It's because he believed there was an attorney-client relationship between him and Trump.
Maybe I'm not clear. Maybe you could spell it out for me. Why does it matter if he's Trump's lawyer versus if Trump had just invited Eastman as a friend or a colleague or a known scholar to come into the White House?
It's the advocacy piece as opposed to the research piece. If all Eastman is doing is just doing some research and handing a memo around at a cocktail party or to Trump or to Pence and saying, here are your options. But it's when Trump dispatches Eastman to Pence's office as a foot soldier in this coup, that's where you cross the line. When you are advocating, "Hey, Vice President Trump, I'm a constitutional scholar. I'm a professor. I've got all these badges of credibility. These are constitutionally permissible actions you can take and you should take."
Mm-hmm.
I'm
just not sure. I mean, you say foot soldier and advocacy, and there's obviously some meaning you're packing into those terms that I'm not grasping. What makes a difference whether Eastman is the attorney for Trump when he's saying these things or just a guest of Trump in the White House?
I guess the unsaid premise is that Trump said, "Hey, Eastman, go next door to Pence's office and tell him there are options that he can do and he should do. And I, President Trump, am ordering him to do this." I guess that's my.
Oh, well, yeah. If that was part of Trump, if Eastman's actions were part of Trump's ordering Pence to do something, then I would agree that'd make a difference. But did it amount to Trump ordering Pence to do something, or just, blathering on about here's what vice president should do if he was a true patriot or whatever else he said?
How dare you? That's our president. He doesn't blather. I don't think we'll ever know what happened inside that room, but the successive meetings in the Oval Office and the next day in Pence's office, and the fact that there's an attorney fee agreement not signed, but between Trump's campaign and Eastman, I don't know. All the evidence points to me that Eastman was carrying out Trump's will in pushing Pence to do things he should not do.
Well, maybe I agree. It was aligned with Trump's will. I just don't understand what role Trump as the president had in that capacity, such that Eastman's representation of the president had any impact on anything, because I just don't see the POTUS as having any impact in the counting of the votes.
Are you telling me
if Eastman were saying, what you should do, you should let the rioters into the Capitol building, in order to put more pressure on the system, that is something that, of course, I don't think we ever got to the bottom of that one. I don't know why they let the protesters / rioters into the building in some places and then try to keep them out in others. Anyway,
they broke it.
Well, some of them broke in. There were videos of others just being let in. Anyway, I mean, this whole conversation makes me nervous anyway. But there was one other topic I wanted to get to.
You're doing fine, Tim. It's gonna be okay. You're doing fine.
Yeah, well, I don't want to get disbarred, Jeff. So I
You
have to
can't
edit
be
this one down.
disbarred for just talking about things.
Okay. Okay. Now, as I mentioned before, any challenges to an election has to be brought lickety split, okay, immediately, or else it's moot. So you have to act fast. But Eastman, in acting fast, and in light of the fact that there were a lot of bonkers theories, a lot of people going to ground trying to come up with information to support claims of election fraud. As Eastman repeated during his testimony, look, I was drinking from the fire hose here. I had so much information coming in, I didn't know which end was up. So yeah, certainly he was looking for, he was, what do they call the difference between research and just, looking for information to support your case. Eastman was obviously looking for information, looking for evidence to support his case. He was not being diligent about evidence that undermined his case. But in his defense, he didn't have time to search the universe of information and totally bulletproof his case. All he had time to do was to do the minimum, which was to come up with some kind of colorable factual theory that would support claims of election fraud. And there was certainly enough evidence, or things that look like evidence, information looking like evidence that would come in that look like claims that would support claims of a possible election fraud. Now, they turned out many of them to be wrong. Some of them not really ever proved right or wrong either way. The election challenge windows are only a matter of days or weeks, as I said. And even Larry Lessig has said, quote, when I looked at these cases, I did feel like there were some where there was more work to be done and they just didn't have the chance to do it, end quote. Meaning some of these claims of fraud could be cast out of hand. Some of them were undermined or disproven, and others were, we don't know, but maybe the trajectory is going in the direction of everything's on the up and up, and there's not anything that's going to show fraud that's going to change the result of the election. So we can just stop. It's safe to stop looking. Maybe that was the official decision, but a lot of these claims were never fully investigated and disposed of. So when I was reading the state bar court decision, I was looking at examples of contemporaneous evidence, meaning evidence that was available at the time Eastman was scrambling to get together a claim. If he was going to bring one, he had to get it together right then and there. And any evidence that would amount to just Monday morning quarterbacking, that here in the light of day in 2025, we know that these claims were false. That doesn't do any good. At the time, if you're going to show that Eastman was reckless or intentionally misrepresenting facts in January 2021, you need evidence, contemporaneous evidence that was available at the time to show that Eastman knew or should have known that this evidence was out there. And most of what I saw in the state bar court decision was either evidence offered by the government, or there was some evidence offered by other experts. But again, in one example I recall, I wonder if I can find it quickly, there was a reference that I found chilling. It was, here it is. It's Eastman, as detailed in the hearing judge's decision and our discussions of the preceding counts, Eastman consistently rejected information from true experts and relied on unverified assumptions and theories. I thought this term true experts was just chilling because I didn't see anything in the opinion that said that Eastman's purported experts were disqualified as experts, such that their opinions were not even credited as evidence. Instead, there's this term, I don't think it's a legal term of art that I've ever heard, true experts. It's just an expert that, well, it might be, this expert opinion might qualify as evidence, but they're not a true expert. So you really ought to have known, you shouldn't have relied on this person. So in other words, if this case had come to me after full discovery, I would agree with the bar court's opinion. But at the pleading stage, when Eastman has only had a few weeks to try to cobble together something, because if he's going to bring an election challenge, it's got to be now or never. I just find it really difficult to look at the evidence and say, yeah, you should have known that this was good evidence, this was bad evidence, this was a true expert, and this was not a true expert. That just seems too onerous a standard to impose on any attorney who is going to bring And not just election challenges. What about attorneys, regular civil attorneys bringing a TRO application at the very beginning of the case before they've had the opportunity to do discovery, and they need to get immediate injunctive relief based on evidence that probably only their client has told them. It's going to be self-serving. They don't get to go and corroborate it. Are they to be subject to possible disbarment if their evidence turns out to be wrong and they didn't go out and perform opposition research to see if there was information that undermined their claims? Or maybe they just pick up the phone and call opposing counsel and they get credible information from opposing counsel who convinces them that they have the true experts and you don't have the true experts. You have, who has the true evidence, who doesn't have the true evidence. Anyway, Jeff, I just think that this is chilling to anyone who's seeking emergency relief in the court and hasn't had a full opportunity to vet all of their evidence. Because a lot of this, the evidence that's relied on to disprove Eastman's claims, I think it smacks of Monday morning quarterbacking, and I think it doesn't really. I'll just say this: I thought that I was more persuaded by Eastman's point that he was drinking from the fire hose, and he had to make fast decisions if he's going to bring this claim at all, because the alternative is just, well, if you're getting a lot of evidence, if there's a lot of signal out there, then you should just assume that it's all just noise, and not bring the claim at all. That seems wrong to me somehow.
Look, I do a lot of anti-slap litigation where there's no discovery and it's flying by the seat of your pants. I agree. I don't think Eastman should be disbarred for things he said in his papers in court or while appeals were still pending from these election cases.
Okay, well, Jeff, we hit your hard stop time, and I'm probably already said many things that could get me in trouble here. So I'm not even going to invite our listeners to respond with criticisms, because they probably already have tuned out and are halfway through a long missive to me explaining why I'm wrong and probably should be brought up for sanctions. So that'll wrap up this episode. Jeff, you want to take us out?
Yeah, if you have long missives, send them to me instead, jeff@jefflewislaw.com. And if you have tips for future episodes or thoughts about Eastman, let us know, and look in the future for podcasts regarding appellate law and hot political topics.
All right, see you next time.